surveillance expansion. Our members fully support the CPSC's mission of product safety and consumer protection and its efforts to advance its import surveillance activities through enhancement of the risk assessment methodology, or RAM, for targeting non-compliant products prior to importation in the United States. RILA also greatly appreciates the CPSC's engagement, including the personal outreach of the chairman, and on the alpha pilot for certificate e-filing, and we have welcomed the opportunity to actively engage with the CPSC on this issue. However, RILA members remain deeply concerned about the proposed e-filing alpha pilot because despite having received significant shareholder feedback on these issues through comments, public workshop testimony, COAC working group meetings, and personal meetings with the chairman, the agency has refused to deviate from the original e-filing requirements as contained in the proposed 1110 rule. Despite continual requests for the staff to demonstrate both how the e-filing proposal itself and the required data fields would improve product safety, the agency has not clearly articulated how its import surveillance targeting efforts would directly and cost-effectively be improved. Additionally, as the agency has recently acknowledged, the technological impediments of implementing e-filing certificates to match individual line entries at import are incredibly challenging for all importers. Further, as RILA has stressed previously, the cost of implementing, maintaining, and operating such an e-filing capability would be staggering and mostly borne by companies who are following the rules and importing compliant products. RILA believes collection of many of the data fields in the proposed rules would add little value to the CPSC's import risk assessment methodology and therefore are not an effective use of resources for the agency and companies who may participate in the pilot program. Consistent with the CPSC's agenda-setting priorities, the agency should be able to articulate the link to improved import surveillance targeting for each data field it will require as part of the Alpha Pilot program. RILA is hopeful that some of the changes that it has recommended, especially the limitation of required data fields to only those necessary for enhanced targeting, will be reflected in the Federal Register notice announcing and outlining the Alpha Pilot program. It would be a disappointing result if all the effort and extensive dialogue between the CPSC and stakeholders yielded an alpha pilot that looks exactly the same as the proposal that the CPSC outlined at the outset of this process. Additionally, RILA members strongly support the development of a trusted trader program as a part of the CPSC's overall import surveillance process and programs. We thank the Commission for allocating staff resources at the CPSC's mid-year to develop a Trusted Trader pilot program and recommend that any new Trusted Trader program should include those companies that are currently participating in the joint CPSC-CBP Importer Self-Assessment Product Safety Pilot Program. Trusted traders should be exempt from any future e-filing requirements in recognition of having passed CPSC's scrutiny of their import and product safety processes, monitoring and oversight, and supply chains. In order to continue building on the progress that has already been made from the Commission's funding of the pilot Trusted Trader program this year, the agency should devote an adequate amount of resources for the full development of a pilot Trusted Trader program in its 2016 operating plan. On the issue of funding CPSC's expanded import surveillance program, the CPSC in its fiscal year 2015 and most recently in its fiscal year 2016 budget request has requested statutory authority to promulgate user fees to fund the nationalization of its import RAM program. RILA members strongly support the CPSC's efforts to strengthen and expand its import surveillance program and have actively engaged with and support the CPSC to accomplish this goal. However, there are significant legal and operational issues related to the implementation of the user fee proposal, and therefore, as we recommended in our Joint Trade Association letter submitted to the CPSC previously on this issue, We recommend that the CPSC seek funding of nationalization of the RAM program from Congress through the normal appropriations process rather than seeking statutory authority to collect user fees. RELA also believes that more stakeholder engagement and transparency regarding the detailed plans for this program must be outlined by the CPSC prior to receiving such funding. Let me turn now to 3 ongoing rulemakings. First, the 1110 rule. In addition to concerns raised by the proposed e-filing requirements associated with the 1110 rulemaking, this rulemaking also contains many other controversial components that warrant similar stakeholder engagement. Some of the pending issues that would greatly benefit from public discussion include the shift of certification obligations from domestic manufacturers to private labelers, the elimination of password protection for certificates, imposition of new and burdensome record-keeping requirements, and the balancing of cost and benefits of the proposal. The CPSC's fiscal year 2016 budget request forecasts that the agency will complete this rulemaking in 2016, and RELA believes that there is much work and engagement yet to be accomplished. RELA recommends that the agency allocate resources to re-engage stakeholders through reproposing the rule, or at least engaging directly with stakeholders on these issues in the same manner that it has regarding the proposed e-filing requirements. On the proposed voluntary recall and 6B rules, although RELA has very substantive objections to these rules as detailed in our comments in these rulemakings, I will not repeat these here because the rules do not appear to be moving forward. A majority of the Commission appears to believe that these process-focused rules do not warrant expenditure of resources among the Commission's other priorities. RELA agrees with this ordering of priorities and requests that the agency accurately reflect whether it plans to allocate resources to the finalization of these rules as it develops its fiscal year 2016 operating plan and fiscal year 2017 budget request. As it stands now, the agency's planning documents conflict with verbally stated priorities of the Commission. There are 4 additional concerns for retailers. First, CPSC's engagement with retailers on product-specific issues. Recently, CPSC staff held a meeting with UL where it was reported that there was a discussion of leveraging retailer requirements to speed desired safety requirements where the CPSC may have difficulties getting provisions into voluntary safety standards. While RELA members are always open to enhancing their internal requirements for the consumer products that they sell, it is critically important that the CPSC understand that retailers are not product manufacturers. As such, retailers do not possess the same product-specific design and manufacturing expertise as product manufacturers and voluntary standard committee members. Accordingly, the changes to technical product design and performance specifications are more appropriately left to the CPSC staff and manufacturing and safety experts who participate in the voluntary standard setting process. The second issue is the retailer reporting program. RELA plans to discuss the retailer reporting program pilot in more detail this afternoon in our hearing on data sources and consumer product related incident information, but we also wish to note that it should be among the Commission's priorities for purposes of this hearing. RELA believes that before the usefulness of the overall program is judged, the Commission should allocate resources to refine and evaluate the program in a manner similar to how the agency is approaching its e-filing alpha pilot. The third issue is the need for increased transparency into civil penalties process. RELA and its members have taken notice of recent civil penalties that have resulted in ongoing litigation with the Department of Justice and opposing statements from commissioners regarding the appropriateness and justification of penalty amounts. RELA believes that the current system in which companies find themselves facing a penalty demand from the CPSC that explains why the agency believes a penalty is warranted, but provides no insight into how the agency calculated the amount of penalty demanded, is not an ideal system. Especially in light of the Chairman's recent announcement regarding future increased penalty amounts, RELA believes the agency should dedicate resources in its fiscal year 2016 to efforts that would provide more clarity, guidance and predictability to the regulated community on how civil penalties amounts are assessed. The fourth and final issue that I will talk about today is recall effectiveness. The CPSC, consumer advocates, manufacturers, retailers, and consumers all share the common goals of timely and effectively informing consumers about product recalls and quickly removing unsafe products from the marketplace and consumers' homes. All stakeholders in the consumer products arena would like to see recall effectiveness improved. To that end, RELA believes that the CPSC should dedicate resources in fiscal year 2016 and 2017 to take a scientific approach and conduct studies and/or consumer surveys on recall awareness trends to determine the most effective methods of communicating recall information to consumers. RELA and our members would look forward to working with the CPSC on this important issue. Thank you again for the opportunity to speak this morning. I am happy to answer any questions.
Thank you, Ms. McGuigan. We'll now turn to our round of questions, and I'm going to probably spend most of my time with you. But before I do that, I do want to note on the subject of window coverings that the Commission did actively participate in Window Covering Safety Month. We just didn't do it in conjunction with your organization. And from my recollection, one of the drivers of that was the fact that your organization was not comfortable with in my quote, or my proposed quote for the press release, my honest characterization from my opinion of the hazard. And to me, that was a bizarre area for there to be a potential intrusion into my own view of the hazard. And so hopefully that won't be an issue. And if we can get together in this upcoming October and I can be free to speak my mind about how I view the hazard and we can work together, then I think we can do that in conjunction. Ms. McGuigan, on the issue of retailers, and there's, again, a lot of subjects that I'd like to cover with you, but I don't think we're going to be able to do it. You're probably happy about that. Do I have it right that retailers, many individual retailers, have their own green chemistry requirements that they require their suppliers to test to?
Some retailers do.
And
yes.
So do they have an expertise in toxicology? How is it that you mentioned that they don't have an expertise in certain mechanical issues, and that really is best left to the manufacturers, yet they do seem to have some comfort, your members do, some of your members do, creating testing requirements around toxicological chronic health issues?
Well, I believe that the retailers that you are targeting or are referencing are two of the major largest national retailers who have a large staff that they're able to dedicate time, effort, and resources to that particular product. That would not be the case with all retailers across the board.
Got it. And is there something unique about those two organizations, though, where they are only able to hire toxicologists, or do they have the ability as well to hire mechanical engineers and others to have similar abilities to weigh in on those type of acute hazards?
Well, the green chemistry that you're talking about deals with chemicals that apply across product categories, not for one specific product category, and it also includes outreach by both of those efforts. And I would certainly, as you are aware, those retailers have been on panels at ICFSO, and you've had conversations with those retailers regarding those specific efforts that they do, but they are engaging directly in outreach and in conjunction with their manufacturers to move forward in that area.
Okay, thank you. And just generally, if you could help me understand how it is that RELA gathers information to present, for instance, at this type of forum. There's a disconnect often, and I spent a lot of time talking to manufacturers directly, not just the larger ones, but other manufacturers, and I spent a lot of time on the road visiting them. There's often, in my mind, a disconnect between what their issues of concern are and what I feel like is presented when we're here in Bethesda, or what I hear is presented through your organizations when I'm on the Hill. And I'm trying to figure out, why might that be the case? Is it that when I visit folks, they're not comfortable telling me